In a media conference today, Harricknen highlighted several areas of concern, including basic civil freedoms.
It may seem a new phase of the SOE, but it is actually a transition. It's come on from the first SOE into the next phase, and in other words, it is a continuation of the SOE under the same controller, under the same deputy controller, for an indefinite period.
Other issues have also included oversight on the powers of the Controller's Office, either by the Prime Minister or the National Executive Council.
There is already a fear in the community of abuse of powers.
With Harricknen saying there is no set criteria and qualification for the position of the Controller, except that he or she should be a public office holder. At present, Police Commissioner David Manning heads the national response as SOE Controller. However, Harricknen says the Act does not provide from which public office the Controller will be selected from, whether it be from the police, defence force, correctional services, health, or other public office, that being left to the prerogative of the NEC. From a financial perspective, he is also concerned that accountability of public funds is seemingly without transparency and accountability.
The Auditor General cannot, or the Public Accounts Committee of the Parliament, cannot come in and independently audit what happened to the funds. So we think that is a major flaw.
That, however, was allayed by Deputy State Solicitor Frederick Tamarua, who says there is accountability being held, despite there being a higher degree of flexibility.
In that. So it is very consultative. The people that need to be consulted are consulted through that process. And I think those are some of the safeguards that have been built to it. So it's not just a reckless allocation of powers. There are accountability provisions which are tied to it.
Prime Minister Marape had said earlier this week that he was willing to accept criticism, reiterating that with the worldwide COVID-19 pandemic, stringent controls were necessary.
Based on evidence and statistics before us, we are compelled to go down this path.
The opposition, however, were one of the first to analyze.
A little skeptical about the effectiveness of those provisions which sort of tried to make the provision in Section 51 look okay.
There is also the feeling that the fines involved are excessive, considering the freedoms and rights being deprived on the one hand, a 50,000 kina or imprisonment for a term not exceeding 5 years, and 500,000 kina in corporate fines for breaches of the emergency law on the other. Harricknen says it will serve as a bad precedent for future governments.
Who is driving this agenda to make a law in a rush in the manner it happened?